Daniel Penny has justly been acquitted by a Manhattan jury of all charges over the in-custody death of Jordan Neely, and now begins the process of rebuilding what he can of his life. Hopefully, given that this experience has not killed him, it will only make him stronger. The rest of us, too, can be made stronger, or at least better informed, by drawing what lessons we can as observers of this prosecutorial debacle. So in that light, let's consider the top 3 lessons we can learn from the Daniel Penny persecution. I am, of course, attorney Andrew Branca for Law of Self-Defense, and for those of you who stay to the end, I'll share with you how you can get a free copy of our best-selling book, The Law of Self-Defense Principles, your handbook to being hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. Let's first quickly recap the essential facts and law in this case. Jordan Neely, a deranged drug addict who happened to be black, with a vast criminal history, including breaking the nose of a woman on a New York City subway, boarded the F train in Soho on May 1st, 2023, and as the doors closed and the passengers were trapped on the car with him, Neely began making credible threats to kill the men, women, and children on the subway car, many of whom were also people of color. The passengers would testify that they were terrified and in genuine fear of death or serious bodily harm at the hands of the threatening, deranged Jordan Neely. Daniel Penny, a passenger on the subway car and a former Marine who happens to be white, physically restrained Jordan Neely until police could secure his arrest in order to defend himself and the other passengers from Neely's threats of death. Penny was assisted in restraining Neely by 2 other men who both happened to be men of color. When police arrived a few moments later, they took custody of a living Jordan Neely, and passengers told the responding officers that they were grateful for Daniel Penny's intervention. Jordan Neely would later die, almost certainly of his own severely impaired physiology, resulting from his lifelong addictions and homeless lifestyle. Following Neely's death, George Soros-funded Manhattan District Attorney Alvin Bragg appointed Israeli-born restorative justice prosecutor Daphne Yaran to try Daniel Penny on charges of second-degree reckless manslaughter and criminally negligent homicide, despite knowing that Neely was alive when he was secured by police. It was these charges on which Daniel Penny was acquitted by jury this past week. Okay, with that background in place, let's dive in to the top 3 lessons we can learn from the Daniel Penny persecution. Lesson 1. No good deed goes unpunished. A common theme among politically motivated prosecutions of the type targeted at Daniel Penny is that almost invariably the defendant charged was rather obviously acting not just in good faith and without malice, but was seeking to be a force for good in their community. For example, when George Zimmerman was compelled to shoot dead Trayvon Martin in an act that a jury would conclude unanimously was lawful self-defense, he was doing so after Martin viciously attacked him. After Zimmerman had phoned local police that Martin was acting suspiciously in the community by walking around in the rain at night and peering into the windows of apartments in a complex that had been suffering a wave of thefts, burglaries, and home invasions. It was this crime wave that led the complex to develop a community watch organization in cooperation and with training by the local police department. And Zimmerman had volunteered his time to this just-formed organization. And it was the training he'd received that led Zimmerman to phone local police when he observed Martin acting suspiciously that night. Despite this context, Zimmerman would be charged after Martin's death with second-degree malice murder and ultimately acquitted by a unanimous jury. Another example is Kyle Rittenhouse, who was compelled to kill 2 men and seriously injure a third with his AR pattern rifle in acts that a jury would unanimously conclude were lawful self-defense. And only after each of those men tried to murder him, as Rittenhouse was present at a Black Lives Matter protest for the purpose of providing first aid to anyone who'd been injured in the festivities. Despite Rittenhouse's good intentions, he would be charged with first-degree intentional homicide, first-degree reckless homicide, and attempted first-degree intentional homicide, and ultimately acquitted unanimously by a jury. As a third example, when Ferguson, Missouri police officer Darren Wilson was compelled to shoot dead Michael Hands Up Brown, who outweighed the officer by almost 100 pounds, after Brown had already engaged in a bloody fight for the officer's service pistol, getting shot in the hand in the process. And then Brown charged at the officer with arms outstretched in attack, in an act that a grand jury would determine did not justify a criminal indictment of the officer. Officer Wilson was and had been serving ably to protect and defend his community from lawless criminals such as Michael Brown, who had only earlier that day committed a strong-arm robbery of a local convenience store. Although Wilson avoided the persecution of a trial, he lost his career and essentially was compelled to go into hiding and begin a new life. Even as violent protests served to riot, loot, and burn Ferguson, Missouri, and other communities throughout the United States. And by the way, the prosecutor who presented that case to the grand jury, which declined to return an indictment, who had been the prosecutor in that jurisdiction for decades, well, he was replaced at the next election by a George Soros-funded candidate who ran on the promise to reopen the Michael Brown investigation, which he did for a few weeks, and then he quietly closed it again because the shooting was obviously lawful. And in this case, Daniel Penny was simply acting in defense of himself and the others on the subway car whom Jordan Neely was credibly threatening to murder by restraining Neely from physically harming anyone and turning a living Jordan Neely over to police. For this kindness and bravery, Penny was charged with crimes that could have put him in prison for 15 years on allegations that he was a white racist killer of a poor, helpless black man who merely needed some help and compassion. Needless to say, a conviction on that narrative would have left Daniel Penny unlikely to have survived even a year in general population of a New York prison, much less 15 years. The bottom line, that you may have acted with the best of intentions and in the spirit of a good Samaritan to help your community and other innocent people, will count for nothing to a politically motivated prosecutor who wants to put you in a cage for much of the rest of your life on specious grounds and contrary to the overwhelming weight of the actual evidence and the applicable law. Lesson 2. The racial grievance industrial complex remains hungry. Because Daniel Penny, the defendant in this just completed trial, was white, and Jordan Neely, the deranged drug addict threatening to murder women and children trapped with him on a New York City subway car, was black, this case re-energized the always simmering racial grievance industrial complex. As has been the case in America for many, many decades, the demand for racism in our nation vastly exceeds the supply. Despite this, racism remains a valuable commodity for raising funds, often for illicit purposes or personal gain, and as political capital to either secure political office or as leverage for politicians willing to pander to the racial grievance industrial complex. Black Lives Matter, for example, has raised many tens of millions of dollars in individual years, with many millions of those dollars having been stolen by various founders of the organization for their personal benefit, according to the organization itself, which has filed lawsuits in an effort to recover funds they say were stolen from them by these founders. As for political capital, in June 2020, the then highest-ranking member of the House of Representatives, Nancy Pelosi, and several of her Democrat colleagues theatrically kneeled in the U.S. Capitol in a moment of silence for George Floyd, the hyper-violent criminal who had held a pistol to a pregnant woman's belly during a home invasion and who died during lawful arrest after fighting police for 10 minutes with a mouthful of chewed meth tablets, severe cardiovascular, respiratory, and metabolic pre-existing conditions, and a fentanyl level sufficient to kill a grown man 3 times over. And in this case, instantly on the heels of the Daniel Penny acquittal, leaders of Black Lives Matter were calling for acts of violence in American cities, including arson, murders, and vigilante justice. All this despite there not being a scintilla of evidence that race had anything whatever to do with the actions of Daniel Penny in defense of himself and others against the deranged, murderous threats of the drug-addled Jordan Neely. Just as there was zero evidence that George Zimmerman, Kyle Rittenhouse, or Officer Dennis Wilson had been motivated in any way by race. The bottom line? Should you be compelled to defend yourself, your family, or other innocent people from a murderous criminal predator, and you happen to be white, and the person against whom you are using defensive force happens to be black, you can be certain that the racial grievance industrial complex will turn its venomous and self-serving rage against you, just as it has against others it perceives as vulnerable to its histrionic racial hatred. And that's true no matter how utterly lacking you may be in racial animus of any sort. And lesson 3, cooperate with the police at your peril. After a living Jordan Neely had been turned over to the police by Daniel Penny, Penny agreed to be interviewed by NYPD investigators. Now, unbeknownst to Penny, Jordan Neely by this point had died in police custody. But the investigators were aware that Neely was dead and that Neely's death raised the possibility of killing charges, murder, manslaughter, criminally negligent homicide charges being brought against Daniel Penny. Instead of informing Penny of Neely's death and his abruptly increased legal jeopardy, investigators conducted a casual, pleasant, joking interview with Penny about what had happened. Again, all the while with Penny believing that Neely was alive and being cared for by city authorities. The video of that casual, pleasant, joking police interview would be played by prosecutors for the jury to attempt to show that white man, that's what they called Daniel Penny, to the jury, that white man as being a ruthlessly callous killer, able and willing to joke with officers after having, according to prosecutors, just killing a black man who was simply in need of compassion, a sandwich, and a safe place to sleep. After being made to feel comfortable with the investigators, one of whom had served in the U.S. Marine Corps, as had Penny, Penny had been read and then waived his Miranda rights, believing that cooperating with the police was the right thing for any law-abiding citizen to do. Penny could have, and should have, instead, have unequivocally asserted his right to counsel and his right to silence, and even more so once he found himself Mirandized, which removed any question about whether he was being interrogated as a suspect in a crime. The only reason you're Mirandized is because you're being questioned as a suspect in a crime. Had Penny asserted his rights instead of chatting away, there would have been no video of a faux-friendly interrogation to be shown to the jury as purported evidence of Penny being a heartless and racist killer. Bottom line, the police are not working for you. They are not your friends. The police are working for the government. And if the government's decided it wants to put you to the test of a criminal trial, the police are there to gather the evidence the government will need to do that. All right, folks, in the interest of time, I'm going to stop right there, the top 3 lessons. There are, of course, other lessons we can draw from this persecution of Daniel Penny. Maybe perhaps I'll do a follow-up sometime, but that's all I have to share with all of you today. And before I wrap up, I do want to share with you, as promised, how you can get a free copy of our best-selling book, The Law of Self-Defense Principles, your handbook to being hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. We translate all the legalese into plain English so you can make better informed, more confident, more legally sound, and more decisive decisions in defense of what you value most. And perhaps best of all, most people tell us they can read the entire book in less than an afternoon. Check the book out on Amazon, where it's 5-star rated, a bestseller, but don't buy it there. They'll charge you $25 for the book plus shipping and handling. Order the book from us, and we only ask that you cover the cost of shipping the book to you. The book itself is free. Get your copy of the Law of Self-Defense Principles right now at lawofselfdefense.com/free book. I'll close out by reminding all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca at lawofselfdefense.com. Stay safe.